Welcome to What's the Scenario with PLRB, where we explore claims and coverage scenarios relevant to insurance professionals. I'm Alicia Watley.
I'm Mike Brode.
I'm Tim Havler.
And I'm Ruth Gottman, Building Codes Department Manager at PLRB.
Hi, Ruth. Oh, sorry. Hi, Ruth.
Hi, Ruth.
Hi.
Tim, what's the scenario?
Tennessee policyholder, homeowner, was making fried green tomatoes when the doorbell rang. It was her neighbor who had an emergency outside, so the policyholder went outside to help. Unattended, the tomatoes caught fire. Flames shot out of the frying pan. Eventually, half the kitchen was on fire. And later, when the building inspector came to sign off on the kitchen repairs, he happened to mosey around back and stumbled upon the rear deck extending from the back of the house, which was improperly constructed and not to code. He would not issue a permit for the kitchen repair until the deck was brought to code first. So the policyholder is asking her insurance company to include fixing the deck as part of the fire claim. Since the deck wasn't touched by the fire, though, the adjuster denied that part of it. Now the public adjuster is coming back seeking coverage for the deck under the Ordinance or Law additional coverage. Policy here is our standard ISO HO 00030511. Question: should the adjuster pay for the deck? On our fried green tomatoes loss, I looked up famous Tennessee foods. I got a nice list for you here. Country ham, fried catfish, Memphis ribs, Jack Daniels, of course, baked beans, biscuits and red-eye gravy, and stack cake. I don't know what stack cake is, but it does sound delicious.
Probably like pancakes with
Is
a
it sweet
Tennessee twist. I don't know.
Sweet or is it like pancakes?
Well, I would assume it's kind of like Johnny cakes. I could be wrong, and all the listeners out there who are from Tennessee are going to be like, that's not what it is at all. But
Right.
Johnny cakes are similar, or like a flatter version of like cornbread, but like made like pancakes. They are flatter. So it'll be interesting to find out what stack cakes are.
Right. We can add them to the show notes at the end, right?
Yeah. This is an FYI. Stack
Right.
cakes are.
That all sound
some
good.
recipes.
And will help me lose weight.
Maybe.
All
Doubt
lean foods.
it. Like Southern foods help you lose weight?
Probably not.
Okay, so we have this claim here with this deck out in the back. And we had a fire, so of course we know that the fire is covered. But that deck really had nothing to do with the fire until the inspector came along.
And what's he doing back there anyway?
Right. He's not allowed back there. He's in the kitchen.
Oh, well, he, just walking around, taking a look, seeing what he sees.
So since the deck had nothing to do with the fire, Tim wasn't damaged by fire. Is this part of the claim? Is it even insurable here under an insurance claim?
Okay, so the public adjuster cited to the Ordinance or Law additional coverage.
Okay.
So let's see what that says. The insurance company is going to pay for, I'm starting the quote now,
Thank you.
the increased costs you incur due to the enforcement of any ordinance or law which requires or regulates, 1 and 2 I'm skipping, number 3, the remodeling, removal, replacement of the portion of the undamaged part of a covered building or other structure necessary to complete the remodeling, repair, or replacement of that part of the covered building or other structure damaged by a peril insured against.
A little confusing.
Yeah,
especially for me. I'm slow this afternoon. But it doesn't sound, at least based on maybe that last sentence, seems to take the deck out of the equation because it wasn't part of the kitchen loss. Maybe?
So it says we will pay for the undamaged part of the building if it's necessary to complete the remodeling repair of the covered part of the building. So
Right.
that word necessary is, could you argue that it's necessary to do the deck because of the inspector? He
Yeah.
has made it necessary for me.
Hmm.
In order to complete the repair, the kitchen repair, I'm going to have to do the deck first. That would be a literal approach. The counter argument here is kind of, I think, where Mike kind of has a gut feeling here, which is, couldn't the inspector really have just seen it at any random time, even without a fire? What if the inspector was just, it's a rear deck, maybe he's just walking by and he happens to see the deck.
Right.
No fire and done the same thing. So you'd ask, did the fire really cause the problem with the deck? You have a lack of a causal connection here. As a counterpoint, we can imagine, what if the inspector said, you know what, you need fire alarms. This building isn't to code because of fire alarms. Okay, now we're at least getting closer to a fire alarms. I can see the connection there. But when you just have zero connection, it's tough. And I'm not going to surprise any of the three of you by telling you the case law is mixed on this,
Of course.
which is why we're talking about it, because it's a hard question. That's what we talk about. Now, since we're in Tennessee, there's a federal trial court which held no coverage in a pretty similar situation. This case is called Chattanooga versus Fidelity. It's a federal court, so it's not binding, but it's going to be considered at least persuasive authority. So I'm going to make an argument in this Tennessee claim against coverage, and I'm going to use that basis. I'm going to use that case as a basis for my argument. Other
Makes sense.
states, could be covered in other states. This is definitely one where you're going to want to check your jurisdiction. And quick plug for PLRB, it's a great way to check your jurisdiction.
I'm going to go back and be just, I'm questioning the fact of whether or not he can withdraw or withhold a permit for the kitchen repair based on the deck.
I'm going to go with, this inspector was
A hater.
acting pursuant to his authority and was within his rights to do what he did. That's a whole separate discussion, which honestly I don't know that much about, but this does happen, I know. PLRB does get asked questions where an inspector is withholding a permit based on something that isn't exactly the thing that was damaged.
So is an inspector's order, does that fall under the ordinance or law definition?
Well, that's a good question, because to even
I
be
know it's a
looking
good
at the
question,
ordinance
Tim,
or
because
law,
I asked it, and I always ask compelling and good questions in our
Mike,
podcasts.
you always know what to ask. So to even look at ordinance or law, we have to first say that an inspector order is an ordinance or law. Huh. PLRB is usually thought it probably is. It's pursuant to the law. It has the force of law. It's a government order, and there's going to be some sort of ordinance somewhere that gives him or her the authority to make that order. So again, you're acting under the color of law, and yep, that's probably going to be good enough. Oh, counterexample here. What if your homeowners association says you have to do the repair in XYZ? You need to put in slate shingles. Now that's different. That's homeowners association. That's a private contract that you signed as part of the association. That is not an ordinance or law. But here you have a government actor.
Said you have no proof that I signed any documents, Tim.
But that's
You
your
watch it
signature
there,
there,
mister.
Mike.
Oh,
All right, so we already established that the deck was already not to code prior to the fire, but could it be like a pre-existing condition?
oh, ho, ho.
I know. Look at me.
Ah,
Pre-existing condition, yes. So if I talk about property being grandfathered, does everybody know what that means?
Hmm. We're just gonna say yes.
oh,
Okay.
sure. Oh,
Well, in case any listeners don't, if you build something and then the code changes, sometimes the code will say existing property doesn't immediately have to be brought to code. Only if it gets redone, then at that point you need to upgrade it so it is to code. So that property during that time and the code before it has to change, that's grandfathered in, so it's in compliance. So if you're grandfathered, obviously it's no pre-existing condition you have to worry about. It was compliant. Now, what if you're not grandfathered? So in other words, you had a current and present violation going on even before the fire.
Yeah, this deck was already messed up before anything
Right,
even happened.
right. Now, surprisingly, the commercial forms have a provision in there saying ordinance or law coverage won't apply if there was a building code violation that existed just prior to the loss. But the
Uh-huh.
homeowners, it's silent as to
Cool.
that.
All
And
right.
if it's silent as to that, at least one court out of Texas, I know, the Benihana case, um, said it didn't matter. It didn't matter if it was a violation at the time. The point is they had ordinance or law coverage, so the ordinance or law coverage was applicable.
Did you say the Benihana case, like the restaurant?
Oh,
Benihana?
Benihana, the
Ooh,
restaurant. It's exactly what you're thinking of.
awesome.
More food in this episode. I like it.
We need more food-related podcasts, you're saying?
I think I am saying that.
Yeah,
Maybe
yeah,
drinks on the
yeah.
next one.
Here we
Well,
go. You're here.
now you're talking. All right, so we're talking about ordinance of law coverage, but wouldn't the contractor who built the faulty deck, would they be considered negligent in what they did?
It could be. It could be that they were negligent, and that could be faulty work if they did something that was below industry standards at the time. I think that's an argument you could make. But again, it's not clear that the policy's exclusions, like faulty work, necessarily apply to override the ordinance or law additional coverage. Yeah, it could kind of go either way on that. I've looked far and wide. I haven't been able to find any case law that is directly on point with this. Just personally reasoning from first principles, you could say the proximate cause of the loss was the fire, the inspector's order as the trigger, as opposed to saying the proximate cause is the faulty work. Um, you might be able to argue that the proximate cause is the faulty work. Again, I think if you're going to make the argument against coverage, the better one would be the first one that we said about the causal connection in that Tennessee Chattanooga case. But this would be another argument, again, that you could make.
Or at least maybe you could go back to your original contractor and say, come here and fix it.
Because you never
Voting
know. Maybe
you.
they didn't have the correct permit. Maybe they
Or
were
they
just.
told us they had the right permits, Alicia, and then they didn't. They
I'm just
lied to us.
saying.
It happens.
It does happen. It happens. I'm still saying that the inspector sucks.
A little too nosy for I'm with you.
That's what I'm saying.
Right.
Hey, he's just doing his job.
Yeah, be in my kitchen, not in my backyard. What if it's a fenced backyard? Why are you all in my business? Are you trying to come back later in the day and catch me on something else?
I'm wondering too, from a building codes perspective, did he get out there with a tape measure and, how did he know that the deck wasn't compliant?
Yeah.
A lot of
Never.
times you can't tell just by glancing at it. So
Don't
Unless
question the inspector, Ruth. Never question.
unless it was horribly falling apart, I don't see how he could just glance
Unless
at
it's
it
like
and
one of those
know.
decks where you knew it's like, who did this?
Right.
All right. So Tim, what can we take away from this scenario?
To recap, we have a kitchen fire. The inspector comes, walks around in the back and sees a deck that is not to code. To Ruth's point, he's a very perceptive inspector and can tell these things without a tape measure. He won't sign off on the kitchen repair until the deck gets fixed first. The inspector's order is probably an ordinance or law, but the insurance company can argue that there is insufficient causal connection between the kitchen fire and the deck, but they should check the jurisdiction for case law on this issue first. So, Mike, what do we have in PLRB's extensive database of resources that might relate to
Well,
this?
I think you answered your own question, Tim. We have extensive information out there at plrb.org as always. And I think there's stuff like Cracking the Code, which is a cool name, navigating the complexities of ordinance and law coverage. That would be fascinating, I think. There's adjuster resource sheets. And of course, our state by state guides are famous, I will say, Tim. State by state guides, which here would have some information on Tennessee faulty workmanship. So reach out to PLRB. You know, we are your resource for all cool stuff insurance related. And Alicia, can you add that and the definition of steak cakes? Stack cakes, not steak cakes. Steaks would be steaks.
Stack cake?
Stack cakes to our show notes
Sure.
today.
Yeah, we'll make sure to have a recipe for it as well. But you can also find a recap of the key points from this episode. You can find links to our social media so you can follow us along and see what's going on in the insurance industry. We'll also have information on how you can submit your own adjuster story. So we're looking for entertaining stories, you know, the kind of stories that you share while you're at a PLRB conference and reminisce and laugh and compare notes. We want to hear those stories. And don't forget to subscribe and give us a great rating wherever you listen to PLRB's podcast. We want to see a nice thumbs up, 5-star. However you do the rating, we want to see it.
Right. And if you have a scenario around stack cakes, please send that in too. That would be perfect.
Yeah, we'll have to make them here in the office. Well, I'll have to make them at home and bring them into the office.
Yes,
So there you
that's a good idea.
All right, everyone. We'll see you guys next time.
Bye, everybody.
See ya.
The views and opinions expressed in this resource are those of the individual speaker and not necessarily those of the Property and Liability Resource Bureau, its membership, or any organization with which the presenter is employed or affiliated. The information, ideas, and opinions are presented as information only and not as legal advice or offers of representation. Individual policy language and state laws vary, and listeners should rely on guidance from their companies and counsel as appropriate.